Hello, I'm Abby and this is my friend Jeannie. Today, we'll be talking about the court's ruling in the case Terry versus the United States.
This case concerns cocaine offenders, and it goes back to 1986. That's when Congress established penalties for drug offenders based on the amount of the drug they were carrying.
There were 3 different penalties. For possessing 5 or more grams of crack or 500 or more grams of powder, an offender received a minimum 5-year sentence. 50 or more grams of crack or 5 or more kilograms of powder mandated a minimum of 10 years. Congress reasoned that crack is more dangerous than powder. This accounts for the disparities in the number of grams required for these prison sentences.
And now for the third penalty. This penalty applied to cases that met neither cocaine threshold. For example, if you're caught possessing 3.9 grams of crack cocaine.
And that's what a jury convicted Terry Victoria of in 2008. While an ordinary conviction might have triggered a 3 to 4 year sentence, Terry was a career offender with 2 prior drug convictions. So, he received a 188-month prison sentence, equivalent to about 15 years, with 6 years of supervised release.
But around the time this was happening, people were questioning the 100-to-1 ratio between powder and crack required for minimum sentences. Why was it that people carrying 500 grams of powder could receive the same minimum prison sentence as those carrying 5 grams of crack?
2 years after Terry's conviction in 2010, Congress passed the Fair Sentencing Act. Under this act, a drug offender had to be carrying 28 and not 5 grams of crack to receive a minimum 5-year prison sentence. For a 10-year sentence, the threshold was 280 grams, no longer 50 grams of crack.
The 2018 First Step Act made the Fair Sentencing Act retroactive. This meant that drug offenders caught possessing 60 grams of crack before the Fair Sentencing Act, say in 2009, could have their prison sentences reduced. That's because under the new act, 280 and not 50 grams of crack cocaine is the threshold required for a minimum 10-year sentence.
After Congress passed the First Step Act, Terry sued. He argued that though convicted under the third penalty, because the amount of crack he was carrying didn't meet the threshold, he should still be eligible for a reduced sentence.
The Supreme Court heard his case in April and released their decision on June 14, 2021. In a unanimous ruling, they disagreed.
The court's opinion, authored by Justice Clarence Thomas, held that the First Step Act doesn't apply to cases like Terry's because they're not covered offenses.
To be a covered offense, the third penalty would need to violate the Fair Sentencing Act, which made changes to penalty requirements. In other words, the changes that the Act made would need to cover the third penalty.
However, the court reasoned that because the Fair Sentencing Act only affects penalties for which there are cocaine thresholds, there is no impact on the third penalty. Either way, with or without the Act, Terry's case doesn't meet the crack cocaine requirement.
Justice Sonia Sotomayor filed a concurring opinion. While she agreed with the court's ruling, she criticized the original 100-to-1 ratio between crack and powder thresholds as arbitrary and shown to weigh unfairly towards certain groups.
However, she noted that changes to penalties lie in the hands of Congress and not of the Supreme Court.
This ruling affects a few hundred drug offenders serving their prison sentences. There are comparatively few because most offenders serving their sentences when Congress passed the Fair Sentencing Act have already served the duration of their sentences. Terry's is a more special case. His sentence is longer because he received prior drug convictions.
And that's a summary of Terry versus the United States. Have a nice day. Hope you enjoyed watching.